Good evening and welcome to the Moot Court of Appeal. Could I please have appearances for who's appearing before us today?
May it please the court. My name is Puttergill, and with my learner junior, Miss Platt, we appear for Mr. Skinner.
Thank you, Mr. Puttergill.
May it please the court, I am Williams and I appear for the respondent with my learned junior, Bergh.
Thank you, Ms. Williams. Right, Mr. Puttergill.
May it please the court. I will be dealing with the highly offensive element of the tort of invasion of privacy surrounding the board's publication. To this issue, I shall be making two submissions. Firstly, that the element is no longer necessary for the tort. And in the alternative, my second submission is that the board's publication detailing private medical information is highly offensive to an ordinary reasonable person. Before I begin, does the bench require a summary of the facts?
Yes, if you could take us through it quickly, that would be great.
Your Honour, until recently, Mr. Skinner was a deputy principal of Riverside College in Christchurch, and owing to photographic evidence of Mr. Skinner attending Narcotics Anonymous, the board conducted drug testing on Mr. Skinner, and he returned a positive drug test result for both methamphetamine and cannabis, and was summarily dismissed from his position. And the board published a statement revealing this information to the public. Your Honours, this case is about an ex-deputy principal who knows the reality of drug addiction and the danger it poses to our community. Drawing from his unfortunate first-hand experience, he has resolved himself to protect the most precious and impressionable members of our community from its grip, and has paid the price for it. Mr. Skinner's case embodies the phrase that no good deed goes unpunished. To begin with my first submission, as set out in paragraph 1, it is for the following three reasons that I invite the court to find that the requirement of highly offensive publicity should not remain an element for the tort of invasion of privacy. Firstly, that removal of the highly offensive element would not lead to absurd results, as the reasonable expectation of privacy is an adequate threshold test in order to prevent unmeritorious litigants. And second, that the aim of the tort is to uphold individual autonomy and dignity by protecting privacy. And in its current state, the test is flawed and leads to misinterpretation. And lastly, that to remove this element would be to develop the tort in accordance with the position in the United Kingdom for the tort of breach of confidence. The bare majority decision in the case of Hosking and Runting created the tort of invasion of privacy, requiring two elements. Firstly, that a reasonable expectation of privacy surrounds a set of facts. And second, that publicity of these facts would be highly offensive to an objective reasonable person. It is this second element that has come under question since its creation. In Rogers and Television New Zealand Limited, two justices of the Supreme Court refused to voice approval for it, feeling that they should settle the matter when the appropriate case arose. And it has further been treated with suspicion in the House of Lords. For paragraphs 1.2 and 1.3 of my submissions, the New Zealand Bill of Rights Act establishes a protection for the freedom of expression at section 14. And this is a fundamentally important right in New Zealand. However, it is not absolute. Section 5 expressly allows for its limitation to the extent that it is justifiable in a free and democratic society. In contrast, the tort aims to achieve adequate protection of privacy interests, which underpin key values such as dignity, autonomy, and the freedom of expression itself. As these are both vitally important rights, an appropriate balance between the two needs to be struck, especially considering that the tort has the potential to frustrate legitimate speech. It is therefore in the public interest that the test employed for this tort is both clearly defined and is predictable in its outcome. The highly offensive test in its current state achieves neither of these. This element inherently requires the justice of the day to make an unduly restrictive value judgment about what is highly offensive with little guiding principles. While this may be useful for disposing of unmeritorious claims, it also acts to dispose of legitimate cases. Justice Tipping described it as unduly restrictive to require offense and harm at this high level, as it undermines the same value which the tort aims to protect. Moreover, this lack of guidance has led the lack of guidance has in the test has led Lord Nichols in the House of Lords case Campbell and MGN Limited to describe it as a recipe for confusion. This effect has been detailed in New Zealand in Brown and Attorney General, wherein Justice Speer found it difficult to apply. Moreover, even the Hosking case does not provide any relief for this uncertainty or difficulty, as neither Justices Galt or Blanchard provide any reasoning for why the test was not met in that case. In Nicole Moreham's journal article entitled "Abandoning the High Offensive Privacy Test," she felt that the imprecise nature of the test has led the tort being misconstrued from protection of reputational harm or embarrassment, wherein it correctly exists to protect the choice about which aspects of one's life they would be made accessible to others. In the words of Justice Tipping, this is the right to have people leave you alone if you do not want private aspects of your life to become public property. And this misconstruction can and has led cases being unduly dismissed. In the case of Andrews and Television New Zealand Limited, Television New Zealand, publication was not held to be highly offensive, even where Justice Allen described the plaintiffs as being greatly distressed by the screening of this program. And this finding is in clear contrast to Justices Galt and Blanchard's conception of publicity that is truly humiliating and distressing. In accordance with paragraph 1.4 of my submission, I submit that removing this highly offensive element would not negatively impact the tort. As Baroness Hale notes in the Campbell case, that the reasonable expectation of privacy is an adequate threshold test, which brings the balancing of privacy and public interest into play. The position in the United Kingdom is that the reasonable expectation of privacy element is adequate to dispose of privacy cases. This is due in part because principles governing this element are more clearly articulated and are reliant on contemporary principles of morals and behavior about what is understood to be unobserved. But the main consideration, as noticed by Justice Tipping, is that the reasonable expectation of privacy is unlikely to arise unless publication would create a high degree of offense and thus harm to a reasonable person. That is to say, a general inherent requirement of the reasonable expectation test is that publication would create offense to a reasonable person.
Could you just take me through that again, possibly in different words, or just step it through? So are you saying that if there is a reasonable expectation of privacy that which is breached, then it will be highly offensive automatically? Could you maybe just talk me through that point again?
Your Honour, my submission is that there are better guiding principles surrounding the reasonable expectation element of the test than the highly offensive element. And this uncertainty has led the highly offensive element to being unduly misconstrued and misunderstood in its application by the courts. And the position in the United Kingdom is that the reasonable expectation test is an adequate threshold in order for the courts to determine it's an adequate threshold test for the courts to appropriately balance the right to privacy and the legitimate public interest. So Justice Tipping's statement is that inherently with the contemporary morals and principles in the reasonable expectation element, it is more than likely one would not have a reasonable expectation of privacy unless publication of the information contained would likely be offensive to a reasonable person and thus harm them.
Thank you, that answers my question.
Thank you. And upon reflecting on the Hosking case, Chief Justice Elias in Rogers notes that Justices Galt and Blanchard saw such a significant overlap between the tort of invasion of privacy and the United Kingdom's breach of confidence that they were essentially the same position. And though there is express legislation in the United Kingdom protecting the right to privacy, as my learned friends note in paragraph 1.8 of their submissions, Lord Hope in Campbell notes that not only has the balancing of these two rights been a part of English law before the commencement of such legislation, but also the gravity of the tort has not shifted since its commencement. Rather, the legislation has had the effect of prompting the courts in being more carefully focused and explicit in their evaluation of the competing considerations. And it is for these reasons that I invite the bench to find that it is an appropriate development of the tort to remove the highly offensive element for the invasion of privacy. And if your honours have no further questions, I will now move to my second submission, covered in paragraph 2. My second submission is that the publication of the board was highly offensive to an ordinary reasonable person. And this submission rests on the following elements. Firstly, that therapy received from Narcotics Anonymous amounts to medical information for clinical treatment. And a reasonable person would be offended at publication of this information. And secondly, that publication of positive drug test results, especially that of methamphetamine, would be highly offensive to a reasonable person. Thirdly, that the informative tone of the publication does not alter the material within it as being highly offensive. And lastly, that the alternative test suggested by Justice Tipping is that only substantial offence should apply, and this is met by the board's publication. Your Honours, at paragraphs 91 through 98 of the Campbell case, you'll find a detailed discussion by Lord Hope on which my case rests. Here it was found that information detailing treatment for drug addiction is of the same accord as private medical information, speaking to the... Yes, Your Honour.
Sorry, Counsel. And by reference to the bundle of authorities, what page am I looking at there for the Campbell judgment?
Apologies, Your Honour, I'm not certain which page it's on. I believe it's paragraphs 91 through 98.
Thank you, I have it.
Apologies, Your Honour. Accordingly, Lord Hope here finds that private medical information detailing treatment is of the same accord as private physical and mental health of the individual. And privacy in this area is a crucial aspect of our health services, as without it, individuals would be deterred from receiving treatment at the risk of endangering themselves and others. And this view is supported in the case of P&D, wherein information relating to treatment at a psychiatric hospital was held to be highly offensive to a reasonable person if it was published. And the very name Narcotics Anonymous highlights the importance of anonymity for the attendance of its members. The board may even have been aware of this as they prefaced their statement, acknowledging that the information was of a sensitive matter. And accordingly, I submit that the publication of one receiving medical treatment of this nature would be highly offensive to a person of ordinary sensibilities if published. In response to paragraphs 2.4 and 2.5 of my learned friend submissions, the current case can be distinguished from Clegg in two aspects. Firstly, that Mr. Skinner's case involves more than just an allegation of police investigation into wrongdoing, as the board reveals specific concrete evidence of the illegal act of consuming drugs. And there is a significant social stigma around the usage of drugs, such as especially methamphetamine. However, this alone may not be sufficient to persuade the court, as the Moot High Court felt that this aspect alone was not highly offensive. The more important aspect which the Moot High Court overlooked was, or which they failed to account for, was that publication of this medical information, that he was receiving treatment from Narcotics Anonymous, as held in P&D, was highly offensive to a reasonable person. Baroness Hale and Lord Carswell, again in the Campbell case, at paragraphs 156 and 166 respectively, note that the sympathetic tone of a publication has no influence on the material within it being highly offensive. Accordingly, the statement by the board contained the phrase, "We wish him well," and that it was of an informative nature to its readers, should have no bearing whether the information it published within being highly offensive. Further, the Andrews case, which my learned friends rely on at paragraphs 2.1 of their submissions, has been widely criticized for its misapplication of the tort, as noticed by Nicole Morham in her journal article. In her criticism, it was noticed that by placing undue focus on the compassionate tone of the publication, consideration was not made for the inherently distressing nature of the contents within the publication. And the case of Clegg is that of the same accord, by shifting the focus from the tort to reputational loss and the corresponding loss of job prospects, which is not under consideration here. Alternatively, in my final alternative, Justice Tipping suggests that a test of substantial offence should apply, and the nature of the material of the board's publication would amount to meeting this criterion. Accordingly, for the reasons that the board's publication reveals highly stigmatized information of drug usage, and it goes further to detail private medical information without the informative tone affecting the content of the publication, I invite the court to find that the board's publication meets its standard of being highly offensive to a reasonable person.
Could you talk me through, please, the difference between something being highly offensive and substantially offensive, or whatever that last point you made was, and where, do you just think the line should be rested lower, and does that make a difference?
Yes, Your Honour, I believe that there is a distinct difference between highly offensive and substantially offensive, as highly offensive is unduly restrictive, and since there is little guiding principles as to what is highly offensive, it is seen necessarily in the extreme that it must be extremely offensive to a reasonable person, whereas substantially offensive is lower than that of highly offensive. And though offence is required for substantially offensive, it is not as high a burden as the highly offensive element.
Okay. Right. Did you have anything further, Mr. Puttergill, or?
No, Your Honour, I believe I'm out of time. So accordingly, that is the case for Mr. Skinner currently.
Thank you. Okay, sorry, who do we have next? Right, Ms. Platt.
Your Honours, this evening I will be addressing why the email sent to parents on 6th November by the Board of Trustees of Riverside College was a breach of Mr. Skinner's privacy. Mr. Skinner, Your Honours, was until recently the Deputy Principal of Riverside College. He is a man who has done his utmost to protect the next generation from the dangers of drugs, dangers that he has unfortunately experienced firsthand. Your Honours, we acknowledge that the Board of Trustees were managing a difficult situation, a situation that no board wishes to find themselves in. But the difficulty of this situation does not excuse the fact that unfortunately they made the wrong decision when they decided to publish private details about Mr. Skinner, a decision that has gravely impacted Mr. Skinner's well-being, and a decision that today we ask that Your Honours takes the first step towards rectifying. This evening I will be making two submissions. I will identify for the bench why the first element of the tort of privacy was satisfied, that is, as set out in Hosking and Runting, that the existence of facts in respect of which there is a reasonable expectation of privacy. And my second submission will address why the defence of legitimate public concern should not succeed in this case. I will turn now to my first submission. It is my first submission that Mr. Skinner had a reasonable expectation of privacy with regards to the information disclosed to parents in the email of November 6th. The Board of Trustees disclosed a number of facts in this email, and I will be addressing two categories of facts private to Mr. Skinner: the details surrounding the drug test and the fact that Mr. Skinner was seeking treatment and that this treatment was from Narcotics Anonymous. Campbell and MGM Limited identifies at paragraph 136 through 147, Your Honours will find this on page 27 and 28 of the case, that facts about an individual's drug use relates directly to their physical and mental health. And further, that information about an individual's health is information that is obviously private. Confidentiality around health information is a fundamental and vital part of our society. I respectfully acknowledge my learned friend's written submission at 3.5, where they have submitted that drug test results were not medical information. However, respectfully, Your Honours, I would submit that a more persuasive argument would be that, as identified in Campbell, that while, for example, a drug test may not be in the exact same category as medical records because a doctor hasn't collected the information, if the information is of the same kind or of that would be recorded by a doctor or analogous to confidential information contained in medical records, such as a drug test or treatment options, then on that basis, those facts are private. Further, while Mr. Skinner's attendance at Narcotics Anonymous falls under the umbrella of information relating to his health and is therefore private, I would further submit that if there was doubt whether this was a private fact, Lord Nicholas and Campbell at 53 provides guidance by clarifying that the whole point of Narcotics Anonymous is that participants in its meetings are anonymous. Lord Nicholas goes on to state that if Miss Campbell had been an ordinary citizen, the publication of this information would have been actionable. This leads to my final point under this submission, found at 3.4 of my written submission. 3.4 does have some overlap, Your Honours, with 3.3 of my learned friend's submission. And I acknowledge that it was identified in Hosking and Runting that public figures may have a lower expectation of privacy. And while I concede that Mr. Skinner's position of deputy principal may lead to some debate around whether he is a public figure, I would submit that if we look to authority, Mr. Skinner does not meet the threshold of what is truly meant by public figure and should therefore not face a lower expectation of privacy. Your Honours.
Morgan, you go.
Wasn't this issue considered in Clegg and APN News where I think it was a principal rather than a deputy principal was held to be a public figure? So I guess I'm just not sure what you mean by a proper public figure. If you could just clarify that.
So two parts to that question. I guess what I was submitting was that with regards to what is truly meant is that of what is identified in Campbell and Hosking, where attributes identifying public figures include household name or being known nationally and internationally, and having a symbiotic relationship with the media. But I appreciate your point and my learned friend's submission as well, that as per Clegg and APN News, principals are considered, or were in that case considered, a public figure. But I would on this point note two facts. First, in Clegg, Justice Toogood said that he was inclined to agree that a principal may have no expectation of privacy, but did acknowledge that his position on this might be wrong. And further, the facts are somewhat distinguishable in the sense that, unlike in Clegg, Mr. Skinner is not the public figurehead of this school. He's not the principal, and he is the deputy. I would submit that this difference is not immaterial and therefore should not be overlooked when comparing those cases.
Perhaps one follow-up question to that. Would it not be arguable that Mr. Skinner is perhaps the public face of the school's drug campaign at the very least?
I think with regards to the facts, Your Honour, it is mentioned that he has spoken publicly, but I don't know I'm not sure that I would agree that necessarily means he is the public face on this. I think at the end of the day, a principal is the leader of the school. They are the face. The buck really stops with them. And I appreciate that he may have some publicity. And I would submit in that circumstance, in the alternative, if you did find that Mr. Skinner to some degree was a public figure, I would submit that degree is slight, and therefore accordingly there should only be a slightly lower expectation of privacy.
Thank you, Counsel.
Thank you, Your Honour. Further, I would draw your attention to Hosking, where Justice Tipping advises at paragraph 239 that even people whose work makes them a form of public property must be able to protect some aspects of their lives from public scrutiny. And we would submit that this similarly is an aspect of his life that he should be able to protect. To conclude this submission, I invite your honours to find, in line with the Moot High Court, that Mr. Skinner did have a reasonable expectation of privacy regarding the details surrounding the drug test and the treatment, because these facts related to his health and were therefore private. Further, Mr. Skinner does not meet the threshold, beg your pardon, Your Honour.
I just wanted to question, surely parents at the school have a right to know if a school leader is taking illegal drugs. Does that not affect your argument that it's his private life and he can do what he likes?
I appreciate the question, Your Honour, and I would respectfully suggest that that relates to my second submission under legitimate public concern. So in that, I will turn to that now, Your Honour.
I'm happy for you to do that, thank you. Or finish your submission that you're on is fine as well. We can come to that.
Perfect. I was simply going to round up, Your Honour, by saying that Mr. Skinner does not meet the threshold of a public figure, so should not be afforded a lower level expectation. If there are no further questions, I can turn to that second submission as discussed. So, Your Honours, it is my second submission that the Moot High Court erred in the finding that there is legitimate public concern in knowing the details around why Mr. Skinner was dismissed. Turning directly to your question, Your Honour, around whether parents might have some concern, I absolutely agree that parents may be concerned about that. Not may, parents will be concerned about their children's safety. You are absolutely right. However, I would suggest that the facts that the board disclosed went beyond what was necessary to allay parents of that concern. Your Honour, at 4.7, I believe, of my friend's submission, they discussed the necessity of transparency. And I guess if Your Honours would forgive my rudimental terminology, Mr. Skinner didn't have to lose for the board to win. I would submit that the board could have been honest with parents to an extent, and that any legitimate public concern could have been met without releasing such private and damaging information about Mr. Skinner. Yes, Your Honour.
Doesn't that run the risk of parents filling in the blanks or assuming the worst and just making speculation that, I suppose, depending on exactly where you draw the line about suggesting what the board should or should not have disclosed? And perhaps that's the first point to clarify, actually, which portions you say go over the line, but more generally, does that not just invite a assume the worst approach by parents?
I understand the question, Your Honour. In relation to which portions might go beyond, I would submit that in relation to my first submission, facts about his health go too far. These would include the fact that he took a drug test, what the drug test was positive for, and the information that he was seeking help from Narcotics Anonymous, so his treatment. But I do acknowledge, Your Honour, that there is the necessary to weigh up that risk around what about perhaps rumours or like you said, information being considered by parents, and then where does it stop? But I do believe, I do submit, I beg your pardon, that the board did not need to go to the extent that they did to allay those concerns. And while there may have been the risk that rumours could have developed from that, it is important to consider that if that does not outweigh Mr. Skinner's right to privacy, acknowledging that that may be an unintentional consequence that is undesirable, but the question here is Mr. Skinner's right to privacy, and that is not outweighed by that concern, Your Honour. Yes, Your Honour.
just exploring that a little bit further, isn't it worse for Mr. Skinner if those parts are excluded? If the board had just said that Mr. Skinner is being dismissed for taking illicit substances, that strikes me as worse than he is also seeking assistance.
Yes, I can appreciate that notion, Your Honour. I would suggest that perhaps that is for Mr. Skinner to decide, and while it does not indicate in the facts that there was a communication or conversation with Mr. Skinner and the board, that information that right was taken out of Mr. Skinner's hand. Further, with regards to whether that rumours may have been more damaging, I think there are processes in place around future employment and things like that that future schools could use to ensure that they investigate those rumours thoroughly. I don't believe, I would not submit, I beg your pardon, that it is up to the board to wave the flag, if you will, or go out to bat to put those rumours to bed. I think they have overstepped their mark, Your Honour.
Thank you.
In the essence of time, I will briefly finish this submission and then move to my conclusion. I would note that in Campbell, it is identified that even public figures would be entitled to privacy regarding their drug use, but for where they have lied about that drug use. And I would submit that this is where the facts of Campbell are distinguishable from the current case. Yes, Mr. Skinner had firm views that there needed to be a deterrent to keep students away from drugs. But did he lie about the fact that he had taken drugs or imply that he had taken drugs? Your Honours, the facts do not indicate that he did. And I would therefore submit that legitimate public concern that arose as a direct result of beg your pardon, Your Honour, sorry.
This sort of raises a bit of an issue I have with both yours and your friend's submissions, saying that he didn't lie by saying that he wasn't taking drugs. I mean, he's put himself out there as this bastion of zero tolerance of drug policy, and there was a reference in your learned friend submissions to no good deed goes unpunished. Isn't he being a little bit hypocritical here? And how do you deal with that issue?
I think the test identified in Campbell is that if the facts have been lied about, the press has the right to put them straight. And if we briefly look at a close reading of the facts, in paragraph 2 it says he takes a hardline approach and talks about their dangers. I would submit that a hardline approach implies he has an uncompromising stance when it comes to children taking drugs, and that speaking about their dangers implies that he has done exactly that, highlighted they're dangerous. I appreciate the notion, but would submit that he's gone above and beyond to protect students from making the same mistakes he has. He has not said he has lied, and accordingly the board didn't have a record to set straight, Your Honours.
Thank you.
In the essence of time, I would turn now to my conclusion. I have identified that Mr. Skinner had a reasonable expectation of privacy and that there was not legitimate public concern to the facts. Mr. Skinner was vocal, absolutely. He wanted to protect the next generation from making the same mistakes he had. It is clear he had been fighting his own demons, but until recently he had been winning that fight. Did he deserve to be dismissed? More than likely. But did he deserve to have these private facts put out in the public domain for all to see his flaws? No, Your Honours, he did not. The court of public opinion has condemned Mr. Skinner. Your Honours, I ask that you do not do the same. If Your Honours have no further questions, that is the case for Mr. Skinner.
Thank you, Ms. Platt. All right, Ms. Williams.
Your Honors, this is a case about a man who could not practice what he preached. A man who broke one law and is now asking this honorable court to change another one to help cover it up. By revealing Mr. Skinner's actions, the board did the right thing. They should not be condemned for it. We invite the court today to find in favor of the respondent and dismiss this appeal. To that end, I will make two submissions. First, the highly offensiveness test should stay the law in New Zealand. And second, this test is not met in this case. I will now move to my first submission. The highly offensiveness test has been a part of this law for over 20 years. And now, Mr. Skinner is asking for the whole element to be removed. I submit that it should stay, and there are three reasons why. First, it protects freedom of expression. Second, it is consistent with domestic legislation. And third, it is also the approach taken in other equivalent jurisdictions. Freedom of expression is expressly affirmed by the New Zealand Bill of Rights Act. Privacy is not. As such, freedom of expression deserves stronger legal protections than privacy. This is the primary purpose of the highly offensiveness test. The test rightly places an onus on the plaintiff to prove why their alleged breach of privacy outweighs the respondent's right of freedom of expression. While without this element, the defense of public concern would still be available, I submit it is unjust to require a respondent defend their enjoyment of an affirmed right before the plaintiff proves their alleged breach outweighs the respondent's right to freedom of expression, which in this tort occurs by proving significant harm through the test of high offense. Yes, Your Honor.
How then would you protect essentially unequivocal breaches of privacy that are maybe quite benign? So for example, if I go to the doctor because I have a cold and then the doctor discloses that, that's hardly highly offensive, but is, I would say, fairly clearly a breach of my privacy going to the doctor.
Yes, Your Honor, the fact scenario you use would likely already be covered by legislative protections. However, to answer your substantive question about small breaches of privacy that are not necessarily offensive, I contend that because freedom of expression, because protecting privacy inherently limits freedom of expression, that some level of harm must be proved to outweigh the right of freedom of expression, because they are not equal rights under New Zealand law.
Thank you.
In direct response to my learned friend's submission at 1.5, while removing this element would of course not result in liability for all publications, it would certainly create liability for more and prevent many others from occurring in the first place. Widening the scope of this tort would likely have a chilling effect on freedom of expression. It would make groups like the board more scared of being sued, which would prevent them from speaking out in the first place when they probably should, rendering any protection of this tort irrelevant. Further, keeping this element not only protects freedom of expression, it also ensures consistency in the law of privacy in New Zealand. This is because a similar test is prescribed by Parliament in the Privacy Act. This was referred to by the majority in Hosking at paragraph 126 as supporting the current formation of this tort. Lastly, support for this test can also be found in other equivalent jurisdictions. The highly offensiveness test was endorsed by the Australian High Court in Lennox Game Meets and is also applied in the United States, where they have over 100 years of experience with privacy torts. While this test is not applied in the United Kingdom, this speaks not to the desirability of the test, but rather to the legislative differences between our jurisdictions, specifically that their Human Rights Act protects privacy and freedom of expression equally, as our Bill of Rights Act does not. And that was referred to throughout the decision in Campbell, however, specifically at paragraph 12. I will now move to my second submission. At the outset, I would like to address my learned friend's submission that Mr. Skinner's treatment was medical information. And because my learned friend stated that this one principle is what his case rested on. Well, with respect to my learned friend, I would like to clarify the claim being appealed today. I would like to bring the court's attention to paragraph 12 of the Moot High Court's decision. Mr. Skinner has claimed that the publication of his test results and his drug use was highly offensive, not his treatment at Narcotics Anonymous. Thus, I contend that any reference to such is not relevant to this appeal. Further, I would also like to clarify the tests being applied in this submission. Again, with respect, my learned friend states it is submission at 2.4, that the tone of publication is not relevant to this test. He uses Baroness Hale's comments in the House of Lords decision in Campbell to support this proposition. However, that authority statement was taken out of context. Her comments in that section were in the section titled Striking the Balance, in which throughout she was applying the test for legitimate public concern. The tone of publication is indeed relevant to the test for high offense and was expressly stated so by the majority in Hosking at paragraph 126. I contend that the test for high offense is not met in this case, and there are two reasons why. First, the information published was not offensive. And second, the way in which it was published was also not offensive. Those two things being true, no reasonable person, even in the shoes of the plaintiff, could have found this publication highly offensive. Mr. Skinner's positive test result and his drug use were not offensive to share because they are the type of information that in an open, fair democracy such as New Zealand is supposed to be shared. It relates to potential criminal activity. This proposition is supported by the decision in Clegg at paragraph 38, where His Honorable Justice Toogood ruled that since the information in that case was related to a criminal allegation, it was not offensive to publish. Additionally, the way the board published this information was also not offensive. The email sent by the board used polite language. Mr. Skinner was not vilified. The board did not sensationalize the story, nor include any photos. The message was in, as His Honorable Justice Alderson described, a measured tone. Further, the email was sent only to those who would want to know, the parents of the children at the school. In summary, yes.
My question was going to be the limited publication to the parents at the school. I mean, you're talking about a very large school in Christchurch that's, once you disclose to those parents, are you not really disclosing to the whole community and possibly all of Christchurch or all of New Zealand by the time you disclose to that many people all of that information?
Your Honor, can you clarify your question, please?
Certainly. Talking about the limited disclosure to only those who needed to know about it, namely the parents, when you're disclosing this to a very large school community, is that not effectively disclosing it really widely to the whole community? I question whether it was really as limited as you're suggesting.
I contend that if the information was shared further, that was not the responsibility of the board. And to speak to my point of who the information was sent to, they hold a direct responsibility to the children and the parents of this school. And thus I submit that if they were to share it with anyone, it would be with them.
Thank you.
Justice Powell, you had a question?
Perhaps just following on from that, was it really necessary to disclose about the Narcotics Anonymous component? Did the board really need to go into as much detail as it needed to? Wasn't it enough to just say that, in fact, couldn't it just say, in fact, that he was leaving his position or had been dismissed, and then deal with any queries on a rather ad hoc basis? Have a pro forma message to give people, certainly, but why not just tell those that actually ask and are interested rather than a statement to all?
First, Your Honor, I would like to address that, again, the claim is not regarding that information, but rather Mr. Skinner's drug use and his drug test. But further, as Your Honor has actually noted earlier, the board likely included this information to present it in a better light. They clearly, based on their language, did not have malicious intent, and my understanding is that they simply wanted to wish him the best and wanted to acknowledge what he was doing for himself.
Thank you.
Thank you. In summary, as both the information published and the method of publication were not offensive, this publication does not meet the test for high offense. And if Your Honors have no further questions, I will now conclude. In conclusion, this tort does exactly what it is meant to do. It both protects privacy, but also ensures that freedom of expression is not unjustifiably limited. This law should not change. Further, the facts of this case do not meet the test for the second element of this tort. If the court is persuaded by either my or my learned junior submissions, this appeal must fail. If there are no further questions, that completes my submissions.
Thank you, Ms. Williams. Ms. Bergh.
Your Honours, at the heart of this community is a school, a place where children spend at least 7 hours a day in the hands of strangers, entrusted by parents to foster healthy behaviours, teach and care for their children. If those hands have been used to consume illicit drugs, the parents have a right to know. Mr. Skinner consumed illicit drugs and tested positive on school grounds. The board made an ethical call to be transparent with parents and shouldn't be penalised for doing the right thing. We ask the court to uphold the Moot High Court judgment and find in favour of the board. To support this finding, I have 2 submissions to make. Firstly, Mr. Skinner had no reasonable expectation of privacy when the board emailed parents outlining the reasons for his dismissal. Secondly, should the elements of the tort be made out, the board has a defence of legitimate public concern, which we submit has been met. I turn now to my first submission. Before I begin, I echo my learned senior's preliminary comment in that the claim by Mr. Skinner is that he had a right to privacy around the drug use and the positive drug test result, not his treatment for the addiction. This has been raised by my learned friend in multiple submissions and relied heavily on in her oral submissions, and I submit this is irrelevant. Contrary to my learned friend submissions, Mr. Skinner did not have an expectation of privacy when the email was sent to parents advising of his positive drug test result in his drug use. The 2004 Court of Appeal case of Hosking and Runting set out the first element of the tort of public disclosure of private facts, that being the existence of private facts in which there was a reasonable expectation of privacy. The appellant cannot rely on this element as drug use is a criminal activity and Mr. Skinner is a public official. In terms of Mr. Skinner being a public official, and contrary to my learned friend submission at 3.4, this matter is analogous to the 2012 case of Clegg and APN News and Media Limited. Justice Toogood held that Mr. Clegg, as the principal of a high-profile private school, could have no reasonable expectation of privacy with regards to his assault allegations. Mr. Skinner, as deputy principal of a very large, high-decile school, attracts that same status, therefore meets the threshold of being a public figure and deserves a lower expectation of privacy. Yes, Your Honour.
Is there not a difference there that Clegg involves what is undoubtedly and solely a criminal act of assault, whereas what we have here is, I suppose, certainly a criminal drug use, but also a medical issue at the same time, and that he has an addiction?
The submission to that, Your Honour, is that certainly addiction carries a certain health aspect to it, which we submit he needs the support around him to be able to deal with that. Unfortunately for Mr. Skinner, this is an offence under the Misuse of Drugs Act and cannot just be let go as it is. It needs to be brought to light, and being the position that he's in, needs to be held accountable for those actions.
Thank you.
His expectation is further lowered because he has courted publicity as he has spoken out at public events about the dangers of drugs and advocated for the expulsion policy at Riverside College. He has therefore become a public authority in the community around drug use. The 2002 case of A and B held, which is submitted, fits neatly within the current fact scenario, that if a public figure holds a position where a higher standard of conduct is rightly expected by the public, or is a role model whose conduct could be emulated by others, or has courted publicity in his position, this would significantly raise his profile and result in a correspondingly lower expectation of privacy. Drug use and a positive drug test result is not what Chief Justice Gleeson, in the case of ABC and Lena Gay Meets, intended to be obviously private, as submitted by my learned friend at 3.2, as drug use is indeed a criminal offence. It is submitted what was intended to be encapsulated under health information is information such as the treatment at a psychiatric hospital as dealt with by Judge Nicholson in the case of P&D. This is vastly different from the use of cannabis and methamphetamine, which are offences, as previously mentioned, under the Misuse of Drugs Act. Yes, Your Honour.
How do you reconcile that, though, with the authorities that do recognise that attendance at Narcotics Anonymous and the likes is something that a person would have a reasonable expectation of privacy? I guess on the submission you've just made, any sort of drug use would automatically disqualify the person from claiming any sort of privacy in that information.
Our submission to that, Your Honour, is that while drug use is a criminal offence and rightly so cannot deserve the expectation of privacy. His treatment and as in the authorities, his treatment at Narcotics Anonymous would more so attract an expectation of privacy. The case referenced by my learned friend Campbell and MGN, in that case, the court held that her attendance at NA was not necessarily private in itself. What was private was all the information in addition to that was published. So her frequency of attending, her commitment to the program, how often she attended and who she attended with, those were published in that case, and that is what was held to be private medical information. That's distinguished from the case before us, where we're dealing solely with the drug use and the drug test result, which does not carry that expectation of privacy or medical information as such.
Thank you.
To support that, we acknowledge that information relating to health does deserve an expectation of privacy. However, in applying the contemporary standards of morals and behaviour, which Chief Justice Gleeson advised we use, we are here dealing with criminal activity which does not have that character of being private facts. Alongside being a public official doing criminal behaviour, Mr. Skinner tested positive while in the capacity of his work. He could not expect privacy as he admitted to using drugs the weekend before being confronted by the school. It would seem that he was doing so in his own time and in his own privacy. However, by the time the school conducted the urine test and received the positive results, Mr. Skinner still had drugs in his system. This changes the activity from being perhaps more so private to a direct concern for the school and the children. Criminal activity by a public official is not private facts, nor should it attract a reasonable expectation of privacy. I turn now to my second submission if there are no further questions. Should the bench find that both the elements of the tort have indeed been met, it is submitted that publication was justified as it was of legitimate public concern. At the outset of my submissions, I stress the fact that the board was informed of Mr. Skinner's behaviour by a tip-off email from a concerned parent. This already suggests there is a level of legitimate public interest in Mr. Skinner's drug activity in the school community. Yes, Your Honour.
Couldn't that also just be a rival for his position out to have him sacked so they can apply for the job? I mean, titling an email concerned parent doesn't strike me as particularly compelling.
Could Your Honour clarify the question for me, please?
Fair enough. Isn't it quite possible that the email was just as likely to come from someone who wasn't particularly concerned and had ulterior motives for raising the issue with the school?
I suppose it could be speculated that that could be the case. However, irrelevant of that, the parents of the school remain to have a legitimate interest in knowing what their children may have been exposed to at the school, and the drug use that Mr. Skinner had been using, I suppose. So irrelevant whether or not the email came from a concerned parent or a potential rival, before us today, that information remains to be of legitimate public concern.
Thank you.
Additionally, the use of cannabis and meth relates directly to Mr. Skinner's occupation, publication of which is justified by freedom of expression and the decision by the board to be transparent and forthcoming with parents. In PND, psychiatric treatment was considered to not affect his occupation or his character or credibility, and was therefore not of public concern. Mr. Skinner's drug use, on the other hand, most certainly relates to his ability and credibility as deputy principal, caring for children of a vulnerable age group, and as an anti-drug advocate. The facts are therefore distinguished from Campbell and directly opposes my learned friend submission at 4.2 and 4.3. With regards to freedom of expression, it is of paramount importance that publicity be given to the misconduct of public officials so that they may be held accountable. Mr. Skinner's use of drugs is a health and safety concern for children that are in his care at the school. Children of a high school age are vulnerable to influences and notice behaviors of those in positions of trust. It is therefore not in their interests to have a deputy principal abusing illegal substances and attending work under the influence. The board was naturally concerned about the health and safety of students, as well as the reputation of the school and confidence that the community had in the school. The 2008 Supreme Court decision of Rogers and TVNZ held that open justice was the key to retaining confidence in the justice system. Likewise, the board did what was expected of them to retain the confidence of the community, and upholding the zero tolerance policy to drugs, which they implemented, is how they saw fit to do so. As already mentioned, the board did not publish, oh, yes, Your Honour.
Didn't they essentially throw him under the bus? I mean, they said that he tested positive for methamphetamine. I mean, they knew that they were ruining his reputation by doing that, surely.
Your Honour, by including the use of methamphetamine and cannabis, it was necessary in the board's eyes to do that because of the effects that methamphetamine has on a person and what it can do to those around them. So meth, as in the fact scenario, can cause a tendency for violent behaviours, and if the children were exposed to that in any capacity, the parents would want to know and most certainly have a right to know. So that inclusion was for the parents' sake and for the community to know. Additionally, it's not for the court to decide what should be included in a publication or not. I think it was held in Campbell that the court should take caution in acting as the editor of a publication. And so minor details, perhaps, which we could perceive here in the court today as what could be excluded, may not have been taken into account in the same light at the time of the publication when the board sent out the email. I see my time is running up, so in that sense, Your Honour, I will move to my conclusion. Schools are a safe haven. The board had a responsibility to be transparent with the community about any risks posed to children in their care. If there are no further questions, that is the case for the respondent.
Thank you very much.
Awesome. Thank you everyone for your submissions. What I will now do is I'll put the judges into a breakout room where they can deliberate, and then they'll come back and give feedback and announce who the winners are. So give me a second to just do that. Awesome, take it away.
Cool. Thank you all so much. That was really awesome. We were obviously took quite a while to deliberate, because I think that it was pretty finely balanced in the end. You all did a really, really good job. So I don't know if you'd prefer to get feedback first or results first, or how you'd like to do things. We can approach it either way, really. I guess in terms of results, so you're not too on the edge of your seat about it. It was very, very close, we thought. In the end, by a relatively small margin, we thought the appellants probably took it tonight. But but it was a close thing, and you all did super well. In terms of comments, we sort of had the similar comments for all of you, really. Really good storytelling in the introductions particularly. There was some really sort of nice framing of what you were trying to do in the story that you were trying to tell, which sort of is a good way to sort of frame where we're going to and what the real essence of the case is. Excellent signposting from all of you, sort of saying that you've got X number of points and these are your points and following them through. Good flexibility in your submissions in terms of being able to move around and not being too wedded to your particular point. And some really good responses to questions, sort of conceding things where need be, and the manner in responses to questions was really quite nice and warmed up quite well and had led to good discussions and sort of delving into it. You all had a really good handle on the case law, which was yeah, really impressive and good, starting with Cameron sort of having a pretty comprehensive knowledge of all of the cases and taking us through, but then you know, on the other side, challenging the interpretation of various quotes and whether that was actually in context, and being able to refer to cases and your responses to questions was, all of you, impressive as well, sort of having that handle, because there was a lot to read and get through. No real issues from any of you. I think your tone and your pace and your sort of persuasiveness was really good. All slightly different styles, but presented in a really strong and persuasive way. You addressed each other's submissions quite nicely without taking it too over the top and while staying with your own. I did think that on both sides you sort of had some, which I think shows a good Moot problem, had some interesting things to deal with, because the deputy principal isn't quite a hero of the people who's just been terribly hard done by, but also is not a devious criminal either. So I thought that the approach from each of you was quite fun in dealing with those issues and the problem. Led to some quite interesting places it took you to, which was quite cool. So yeah, I thought that was quite well balanced. Morgan, did you have anything to add?
Really just echoing what you've said there, Kristen, that look, it was a finely balanced exercise in the end, and yeah, you all did really well. Yeah, in particular, I certainly like that you all essentially used your submissions as something of a roadmap. Rather than reading through them, you use them as the base point and then elaboration on points. You know, good referring to authorities. Appreciate it's hard via Zoom as well to make sure that your judges are actually keeping up with looking for the right pages and looking at things like that. But I felt your overall pace was good, and everything in the written submissions was well footnoted and whatnot for making sure we were on the same page as you. And then, yeah, in particular, I felt all of you dealt really well with questions, which is often the trickiest point of responding to whatever sort of flickers through the judge's mind or takes their interest. And all of you did a good job at, yeah, fielding the questions or asking for the question to be rephrased or clarified. Or indeed, I can't recall who it was, but deferring, yeah, asking the question just to be dealt with essentially in the next section where it was going to be addressed, rather than disrupting the flow of the submissions. So look, other than that, don't have anything to add to what Kristen said.
Brilliant. That brings us to the end of the Gully Junior Moot. Before we wrap things up properly, I will extend a few thank yous. First of all, to Kristen and Morgan, thank you for taking the time out of your night to provide your expertise and all your insight. I'm sure all that feedback will be super helpful to our mooters when they moot in the future. And thank you to the mooters for such an entertaining moot. Echoing what Kristen said, love the storytelling. Looking forward to seeing all of you moot into the future. I would thank our audience, but unfortunately we are not live. But thank you to future audiences that happen to watch this right to the end. Thank you for coming. And yeah, a huge thank you to Gully for making this possible, for providing financial support as well as people to make it actually happen. Yeah, and thank you to Gary for organizing it. It's been fantastic. Yeah.
Thanks for bearing with my poor technical skills.
Thank you.
Thank you very much.
Have a very good night.
Have a good night.
Thank you for your time.
Thank you.
Thank you, and congratulations, Sarah and Cameron.
Yeah, congrats.
Thank you, guys.
We shall moot again.
Third time's the charm, rematch.
Bye.
No.